motion on the clerk general?
So moved.
And yes? And how about the requisitions, Tom?
I approve of those two, so moved.
Okay, great. Do we have any add-ons?
I do not have an add-on, but I do have one item for consideration, not on the consent agenda. I've got a resolution authorizing the Director of Warren County Children's Services to establish bank accounts on behalf of children in custody for the purpose of conservation of accruing benefits.
Yeah, so this is for the Social Security issue, correct?
Correct, I mean, this was, I mean, Tanya's here if she wants more detail, but basically, I
Tammy,
think,
why don't you just come up and, I'm familiar with this issue, but my guess is Commissioner Grossman is not. It's pretty straightforward, but,
Yeah, there was some new legislation passed last year, and out of that, a new rule where a PCSA, so Children's Service Agency, is required to conserve Social Security benefits for children in our custody. So we have reached out to different banks to see what our options are to do that, because a lot of our banks were requiring another party's like Social Security number, so like my Social Security number to set up these accounts. But we did find Fifth Third, who is able to do that with our tax ID number. So it'll be set up for the child, and then we would be also on the account as an agency.
and so why don't you explain how previous law, or how they were, maybe it's not previous law, how in previous practice those monies were utilized, and now how the new law is
Yes.
impacting it.
So yeah, previously those, the money that children were receiving from Social Security was able to be applied towards their placement costs while they were in our custody. And then that changed out of this House bill last year, where they want us to begin conserving those benefits for the children. So when they age out of our care, or they're adopted, or they enter somebody's legal custody, that money would transfer to an appropriate party at that time for the child.
So the important thing is that previously, the Children's Services, we utilized those funds that were for particular children, that Social Security, they had some revenue coming to those children. We would use them to offset our placement costs, and no longer is that allowed to happen. So you wanna set up these custodial accounts
Correct.
to follow the law, there.
Yes.
Okay, and I assume that that's already been cleared through the prosecutor's office?
Yes, we've had discussions with them.
Okay, Tom, do you have any questions
No,
about
I
that?
don't.
Okay,
All right,
great,
thank
thank you
you.
for being here.
You're welcome.
So we just have a resolution,
Correct.
do I have a motion?
So moved.
And yes? Anything
And
else?
that's all I have.
Martin?
no, I mean, the only thing I was gonna sit there and say was I was just going to thank everybody, because obviously we don't normally get a foot of snow or whatever the total was. But wanna thank Susan and I were on a lot of communication strings with the engineer in the sheriff's office relative to road conditions and things of that nature, so I wanna thank them. Also wanna thank, obviously, there are offices that we have that are 24/7, like dispatch and our facilities and technology services was working around the clock, and they had different shifts. So coming onto the campus yesterday and even today, they've done a very nice job and kept things going. So I just want to thank all the directors for doing a good job, and wanted to say that publicly. So just want to appreciate their efforts.
I concur, the county roads look good, and I know there were short of sleep, so hopefully they'll be able to rest up here soon.
Yeah, how did that one overturned plow and salt truck get in that position?
Actually, I think they were still looking at it. I can ask Engineer Weber to see how, I mean, we know that the driver was okay. My guess is just potentially side of the road, maybe in a little ditch. I haven't heard, the one thing was it was an older truck, so it wasn't anything that was new. So obviously you don't want any trucks to be damaged, but being that it worked out. But I'll get more details, because Engineer Weber hasn't shared those with me yet.
Oh, okay, yeah, you had mentioned in the text messaging that the driver was okay.
Yeah.
And that it was an older vehicle. Okay, well, thanks, I'm interested in that. You know, I raised an issue about a solar array in a front yard that was contrary to our zoning, and there was a gentleman that was gonna come in today who apparently lives next door and also has control over another property. But then he informed me that maybe he wasn't gonna come in today because there was some action being taken on this. Do we know about this?
Yes.
I was gonna say Bruce has been working on it, but I don't, not for today though. Might, in the future with Bruce.
This is Cox Smith Road in Union Township. There was a property owner that applied to put in ground-mounted solar. And the zoning department, the assistant zoning inspector, issued a zoning certification that went to the building department for him to do that. The zoning inspector failed to contemplate that we had maybe a year prior to that done a zoning text amendment that had small solar regulations. In small solar regulations, there was, as part of the code, a prohibition for the solar to be in a front yard. The way the assistant zoning inspector reviewed the case, she just reviewed it under the accessory structure section, and it allows a use, an accessory structure to be in a front yard as long as it's, I think it's 200 or so feet, maybe it's 150 feet from the right of way. And this structure, the person was proposing on Cox Smith Road was something like 250 feet away from the right of way. And it's very wooded out there, but apparently it got put in pursuant to that zoning certification and a building permit, or at least a zoning certification. And the neighbor 2 properties away, and if you're familiar with that area out there, everything out there pretty much is 5+ acres or more. So they're large estate lots. And so the gentleman you're probably referring to engaged the zoning department and articulated very well his position, but he had failed to file an appeal as an agreed person within the statutory limitation to do so. Then he tried to articulate an argument that, well, he was trying to appeal something he was told in a telephone conversation, and I gave an opinion that you can't appeal that. He's trying to fabricate some later in time to start the clock running. But after that, the zoning or the building department discovered that the property owner that put in the solar array, as you referred to it, I'm going to call it ground-mounted solar, which is more on point for this exact scenario that's going on. He also put in an accessory structure with building permits, but he put solar panels on top of the accessory structure, which he's allowed to do. No prohibition to that. But he did it without a building permit. So the building department decided to cite him for that. And then when they informed me they were going to do that, I said, you've got to go back and cite him for the other. We made a mistake. There's case law, the 12th Appellate District on point, where that's happened. So the property owner that's 2 properties away, I'm just speculating, is maybe who communicated with you, who may have come today. He may not be aware of it yet, but he will be made aware of it because I had the zoning department send notice of a hearing coming up in February because the property owner that installed the ground-mounted solar has hired an attorney, and they have filed an administrative appeal to the Board of Zoning Appeals. So even though our code didn't expressly require it, I had the zoning department send notice to all the property owners within 500 feet so that they could come and participate in that hearing. But that hearing is really limited only to the issue, did the zoning inspector, when he issued the violation letter, did he improperly interpret our zoning code? That's what that issue, that'll be heard by the BZA. That's the only jurisdiction that they have. The attorney that filed that administrative appeal is trying to raise, well, you gave us a permit and now you're telling us we don't have a permit, we're not allowed to do this, and somehow he's trying to challenge that. What's interesting about all of this, if you followed any of that, is the 12th Appellate District case I'm referring to was out of Clear Creek Township a number of years ago. 2009, I believe is when it was. It's the same attorney. And the attorney lost the Clear Creek Township case, and now he's bringing this case in Warren County. And he's also alleging that there's been an unconstitutional taking by regulatory means. He made the same argument in the Clear Creek Township case, and it never got a decision, a separate case of the unconstitutional taking, and the court never reached a conclusion back in the Clear Creek Township case because they missed the statute of limitations on filing such a case. So there was no decision on the merits. So anyway, February, maybe 3rd, somewhere early February, we've got a hearing in front of the BZA, and this gentleman, again, I'm speculating, it's this gentleman 2 doors down. And his complaint was, I guess there's no trees that buffer between his property, the property owner in the middle, and the property he claims should have never gotten a permit to begin with. So we're trying to fix it, is what we're trying to do.
And one of the things that was curious about it to me was the question of us making a mistake and then issuing a permit for somebody to do something that's directly contrary to our zoning when there was no variance given, and that somehow it was all okay then, which surprised me, that somehow you could get into a position of, oh, we make a mistake, which we did, and it was an honest mistake, because it was based upon somebody who didn't know we'd changed relatively recently the rules about this solar, whatever it is, ground zoning or array or whatever it is. And then all of a sudden that was like, oh, it's okay, which surprised me. But then the other thing that came up when I was talking and making inquiry about it, and this gentleman did talk to me, I was wondering, how would he know when the deadline or when the whatever the time period to object started? Because the public wouldn't normally know when, say, a permit was issued. So if the issuance of the permit is what starts that 30-day period or whatever it is, but they don't know it until something is being built, which may be days or weeks later. And then all of a sudden, they miss the time because they don't know how to measure the time. And I'm wondering, Bruce, if that's an accurate description of part of what happened here, is there a way for us to fix that problem that people would know, or not really?
No, you don't want to go down that road. You don't want to go down the road that every time some contractor, builder, developer comes in to apply for a permit that requires just an administrative review by someone in the building department or the zoning department, that somehow it all of a sudden blossoms into a process where we have to give notice to a bunch of people. If our code, if the state code for building, if the county zoning code allows something and there's no permit that has to go through, or there's no public process required, that would drag our system down beyond belief, and you would get such a pushback from the builders, the developers, the property owners. It's, Ohio law doesn't require it. I understand what you're saying is a matter of fairness, common sense, if they didn't get notice. And you're also making an assumption that there was some delay between when the permit was obtained and when the construction started for them to see it. I don't know that. Maybe that's the facts. I don't know.
Well, I don't know what the facts are. I'm just asking the question. So, recently, in the law in Ohio used to be, just to have the public understand the issue that we're really talking about here. The law in Ohio used to be that defamation statute of limitations started. And that, so for so part of the problem that we're talking here is a limitation period on when a neighbor or whatever can object to some permit being issued. And in the case of defamation, it used to be the law in Ohio that the defamation statute of limitation, which is relatively short, starts when the defamation occurs, which makes sense. But let's say the person who is being defamed has no idea that this has gone on. And in fact, the statute of limitations can run before the person even knows the defamation occurred. In that case, went all the way, the 12th district had that case. They then created the rule that said that a person, the statute of limitations in defamation occurred when the person reasonably should have been aware that it had occurred. And that went all the way to the Ohio Supreme Court. The firm I was along with, Taft, was on the opposite side of this, but they lost. And the court held that the statute begins to run at the time when the person reasonably should have been aware of it. And so my question would only be, is there some reason why that would be a problem, to having a reasonable standard of when you should have filed, when you should have been aware, that people would object to that? Because it seems to me if there was some draconian result, which is we have an express violation of our zoning code, we make a mistake, we apparently gave a permit, the neighbor doesn't know about it until the building starts, and you're right, I don't know when any of these dates occurred. But if the result of all of that was that the only recourse of the person is to initiate their own individual complaint, I'm wondering if having a reasonable, a standard like the one the Supreme Court has ruled is now the rule in defamation cases, if that would be a problem.
And my response to that would be Lebanon is the wrong place to pursue that. It's Columbus. We have a state statute that says they have 20 days. We're obligated to follow the state law, the enabling statute for zoning, and if the state legislature wants to change that and build into a known or should have known or reasonable period of time, whatever the standard might be, that we could follow, then we could follow. The other thing that I concluded in that case when I made that, gave that advice to the zoning department was this property owner had another remedy. There is a remedy under Ohio law that, just like we bring zoning enforcement cases for someone violating our zoning case, or our zoning code, if we choose not to pursue it, or even if we choose to pursue it, an individual property owner has standing, they can bring an enforcement action. So this gentleman, even though, albeit he'd have to hire an attorney and go do this unless he did it pro se, he has another remedy. He could have filed an action in the court. And if something gets in court where the judges can review whether or not the case law you're talking about should be applied, that's one thing. But to have our departments, our volunteer boards and commissions try to apply these standards, they just can't do that. And we can't come up with a standard that you're asking about because the state law says it's 20 days on this type of thing.
Let's answer the question. All right, well, thank you. And in the case, the very argument in the defamation case was that the law said that it was the accrual of statute of limitations was the time of the defamation. They made that argument, and the Supreme Court, however, in that case, reversed it, but it was a court-created rule. I'm glad that this is being resolved, because, and by the way, question, when there's a heavy snow predicted, should people take their cars off the street where they're allowed to park? I noticed, even coming in here today, there are cars that are literally snowed in by the plows, and I know that one of my sons who lives in Cincinnati had his car, and you can only park on the street in this downtown area. And so everybody does, and their cars are all plowed in by snow. And I had, of course this is Mason, in my neighborhood, the snow plows plowed the snow so that you had this huge bank of snow in front of your driveway.
I do know that there are certain jurisdictions, actually, the one that I live in and the one north of me, who actually send out notices, or I think they're like a one call and everything to move your cars off the streets. I mean, something that we can do through our social media. I don't know that the county has any specific regs on it, but I do agree. I mean, just for the mere fact of you lose mailboxes, you're running the risk of a plow hitting your car and those types of items. But I know that the folks that plow would very much not have to work around cars, but we can make, there's no official rule that we have, but we can make notices and request that from folks. But I think it falls usually within those jurisdictions that tend to sit there and ask for folks to do that.
We have limited authority to designate no parking areas, and some of those are for that purpose. But we have limited authority on that. But that's a very good question. I've had that question all weekend about Cincinnati. When they're told to take their car off the street, where do they take it? Because a lot of places, they have on-street parking and nothing else.
That's exactly what my son is. There's only on-street parking. There are no, because there's a lot of these old row house areas have no garages. They were built when nobody had cars. They're historic structures that go all the way back into the 1800s, and everybody's parking on the street. And it's sort of like, oh, I'm supposed to take my car off the street? What am I, you're supposed to put it on the roof? Or you're right. I mean, and their cars are all plowed in with snow. Literally, they have to do this archaeological dig to get them out.
We'll take the 12, 13, 14 inches and amplify it by the plow. So yeah, absolutely.
Yeah, I don't know. But in my cul-de-sac, I had a neighbor who literally had a 4-foot wall of snow in front of his driveway. It took him all day to dig that out. And I had a lower one. They didn't do it as badly on me. And I'm thinking, somebody didn't know that this guy had a driveway there? I don't know. And no, it wasn't us. And Mason is really good at removing snow. I've been pleased with how effective they are. All right.
Okay, great. Is there anything else that you have?
I do not, staff does not.
At this time, is there anybody who's here who'd like to address the board? Good morning. If you could state your name and address for the record, please.
Yes, ma'am. I'm Warren Miller, and I live at 1586 East Lower Springmore Road, Waynesville, Ohio. So, I have a few copies for y'all if you would like them.
Great.
So,
I'm going to hand them to the clerk, please.
I'm Warren Miller, and I am a 6-year 4-H member in Warren County, and I also serve on the Junior Fair Board. And please let the record show that this is a personal testimony, and I am not a statement on the behalf of 4-H or the Junior Fair Board. However, within that organization, I have sworn a pledge to lend my head to clear thinking, my hands to larger service, my heart to greater loyalty, my health to better living, for my club, my community, my country, and my world. Today, I am here before you representing my community. As a devoted 4-H'er, I am invested in anything concerning the Warren County Fair. I attended the Agricultural Society meeting last Monday and the previous commissioners meeting in an attempt to develop a better grasp on the situation at hand concerning the sale of the Warren County Fairgrounds, a sale that directly impacts me and over 900 4-H families in Warren County. I have a few questions for you today. Before I begin, I know and understand your protections under the Ohio Sunshine Law, ORC 121.22G2. As a high school student, I have learned through my experiences in mock trial, traditional logic, and team policy debates the importance of defining your terms. Please help me define the following. Fairs as referenced in ORC 1711.15. So ORC 1711.15 states, in any county in which there is a duly organized county agricultural society, the Board of County Commissioners or the County Agricultural Society itself may purchase or lease for a term not less than 20 years a real estate on which that holds fairs under the management and control of the County Agricultural Society, and may erect suitable buildings on the real estate and otherwise improve it. So I would like to ask, what is your definition of fairs in that section?
You want us to answer these questions now, or why don't we go through your whole process and we'll come back to them?
Alrighty. Second is necessary size.
By the way, do you want to be a lawyer, Warren?
I mean, in mock trials, I am a lawyer, yes.
Well, but I'm wondering if you want to be a lawyer in the future. That was my question, really.
Probably not.
Okay, because I was going to warn you. Yeah, I was going to warn you that I'm a lawyer, and I told all my 6 kids not to do it. But go ahead.
Necessary size in ORC 1711.26A1, and that as follows is a county agricultural society or independent agricultural society may sell any part of the premise that are used by the society as a site on which to hold annual exhibitions or exchange any part therefore for other lands if such premise are in the possession or under the control of the society, and either of the following apply. 1. The premise is greater in size than is necessary for the purpose to which they are devoted. 2. The premise are not suitable for their formation or character for the purpose to which they are devoted. Third definition is formation in the previous clause. Third definition is character in the previous clause. And the fifth definition is purpose for which they are devoted in the previous clause. Now that we have, or attempted to, define our terms, I have the following questions. What was the last time that each of you attended a Warren County fair?
Oh, every year.
Yeah.
Do you believe that the fairgrounds are greater in size than is necessary for the purpose to which they are devoted?
Well, we'll answer your more substantive questions. Can we hold them to the end? Because there's a lot of your questions that we'll ask our law director to comment on.
Okay.
And then also, I'm gonna ask him what we're allowed to comment on. Because to some extent, things could reference our executive sessions where we're not allowed to do it unless the commission as a body allows us to do it.
Okay.
So my preference would be we get through the whole presentation.
Yeah,
Alright.
I think that makes sense.
Are the premises not suitable for the formation or character for the purpose to which they are devoted? What is your involvement with the execution of the fair that would give you authority on defining size, formation, or character? How many of the current 900 4-H families, your constituents, have you spoken to regarding the sale? Just a basic for or against conversation. Have you spoken to any at all? Why is this not a ballot issue? Has the precedent of selling a fairgrounds to a city been considered? Has setting a new precedent an impact to the future of Ohio Revised Code and the reach of the precedent across the country by selling a county fairgrounds to a city been considered? According to ORC 1711.15, quote, the board may appropriate from the county's general fund or permanent improvement fund, end quote. Can anyone tell me why that has not been proposed as a solution? According to the Lebanon City Manager, Scott Bronco, the city proposed applying for a capital state improvement grant. Can you help me understand why the county has, to my knowledge, never applied for this much funding needed for our fairgrounds? To that point, can you tell me why Warren County cannot financially support their youth through retaining the ownership of the Warren County Fairgrounds, despite in Commissioner Young's bio on the County Commissioner's website reporting, quote, Warren County is widely regarded as being in the best financial position of any county in the state and arguably the nation, end quote. And to put it bluntly, why? Why are we selling this property? If you can't answer that last question with confidence, I can tell you the conclusion that I draw. I believe that this deal focuses on a structural management change for the purpose of redevelopment rather than the 900 4-H families that it directly impacts. This year alone. A short-term solution with long-term consequences. Let me remind you that as a 4-H'er, I pledge my heart to greater loyalty. Today I ask for your loyalty to the community. Let the record show that I am against the sale of the Warren County Fairgrounds. Thank you for your time.
Thank you, Warren.
Thank you.
Nice job.
Yeah, really appreciate it. I'm glad you got out of school today, if you're in school to do this. And you go to what high
I'm
school?
homeschooled.
What's that?
Homeschooled.
You're homeschooled? That's great. I was the legal
He's
counsel.
in school right now.
Right,
Yeah.
exactly. Well, this is part of your schooling, and I take it that's your mother back there, is that
Yes,
right?
it is. Yeah.
Well, you're raising a very fine son. I was the legal counsel to the Homeschool Legal Defense Fund for many, many years. And I applaud that. My brother homeschooled. My kids all went to Mason, so they didn't homeschool, but my wife wishes we'd done some different things with that sometimes. But, hey, look, do you live on a farm?
Yes, sir.
Uh-huh, and what does your farm do?
We raise rabbits, so.
Do you?
Yes, sir.
Okay, and do you have a lot of rabbits then?
Yes.
They just sort of propagate. Oh, I grew up on a farm too. We did horse boarding. We also had a sharecrop. We had soybean fields and stuff like that. And my family also had a farm here in Warren County, but I grew up in Hamilton County. So I'm very familiar, and I went down to the Hamilton County farm, was in Carthage, and that's where it's been for many years. And I don't know how long, Bruce, has the fair been at the fairgrounds here in Lebanon?
The fair.
Yeah.
I can only speculate based on when the original land acquisitions occurred, and it has been 1 century.
Okay, so it's been there a long time. So with regard to some of his questions, Bruce, is there anything that you'd like to comment on?
No, not in the public meeting. What has happened, we have related a message that if the commissioners decide to sell the fairgrounds to the city or anyone else, that the commissioners are probably going to hold a public work session where the community is given notice and invited, and they can come and do exactly what this gentleman has done today and articulate their view and thoughts and requests to the commissioners before they make that decision.
Yeah, and I can tell you that there hasn't been a decision made with regard to selling the fairgrounds. We have sold property that's nearby. We sold property to the south of the fairgrounds, which was then developed as the North Broadway project. We first, heard that there might be some interest of this, I think around in October of 2024, at which time, if you look back in the public record, we heard that the fair board had ordered all of the horse boarders there to remove themselves from the boarding operation that they'd had for many years by December 1 of that year. And we then had discussion about that. You can look at the public record to see what that discussion was, but ultimately that was postponed, and they've not been required to leave. But there were issues, financial issues. I can tell you from my own standpoint, the comment, and again, we can't go into what's been an executive session of the comments there, but I can tell you that I have received lots of calls from people, including many people in 4-H. And maybe that's because I have a farming background. I don't know. But I will tell you that money is not the issue in terms of if there's a sale, there's going to be a money question. But it isn't the cost of the fair or that, in my view, this is my personal view, that relates to the sale of the fairgrounds. That's not the issue. And there was a person that I think was here last week maybe. Were you the one that, yes? Because you made comments too about the money issue. And for me at least, that's not the question around the sale.
Yeah, so the Warren County Agricultural Society that is in charge of running the fair, they are in a declining financial state.
That's been an
That's
issue.
an understatement.
That's been an issue, and their reporting and the quality of the reporting on that. And if you go back and you look at our October meeting, I believe it was, when we addressed this in 2024, which I think you can get online and see, you'll see that was discussed. Yeah, we're aware of that. That isn't an issue.
Well, and I guess I would just say, since what our legal counsel said is right, we're gonna have a public hearing if there is something to bring forward. But speaking for myself, but I think it's true of the board writ large, is our motivation behind even entertaining it is largely about preserving the 4-H program and deep concerns around the long-term health of maintaining the of the programming if the status quo is maintained. So while I think the details are still being worked out, and we don't know for certain that something will happen. But there will be an opportunity for people to weigh in on that when we have something to provide. Speaking for myself, it is out of deep, deep concern for wanting to maintain 4-H in this community, because we see it as something both valuable to young people from a leadership standpoint, whether or not they continue on in agriculture, we think it's important, but certainly also to our county's history. So I personally appreciate you being here today and sharing your concerns and asking your questions. And hopefully sometime soon we'll have a public hearing and be able to talk about it in more detail.
All right.
And I'll tell you something else more. You know, I was on Mason's council for 11 years. And one of the things that I found, and I objected to when I was on council, was the fact that you could go into executive session. Now, of course, you know, under Ohio law, there's what they call the Sunshine Law. And we have to have public meetings. We have to give notice of public meetings. We have to have discussion in public. We commissioners also cannot kibitz with each other about legislation and things when you're a majority, and you could, and because that violates the Sunshine Laws. So we don't do that. And with regard to property transactions, you can go into something called executive session for a very few topics. And one of them is the sale and acquisition of property or real estate. And so that happens. And I do not like if you go into executive session, you have these private conversations about the sale or the purchase of property, and then you immediately come out and you have the body decide the question. Frequently, as a Mason, you're doing these again, because our meetings would start like at 7 o'clock in the evening. We would get into executive session after all the other business was done. Then we would come back in and maybe act on something at 11 or 12 at midnight. Well, that's not going to happen in this case. There's going to be a hearing. There's going to be a work session. There's going to be something that the public can come in and look at whatever is being proposed. And I know that there have been term sheets that have been exchanged. And when that happens with Lebanon, I believe that people have made, because there's a law in Ohio that says that if there's a public document, unless there's certain privacy concerns that have been recognized, those are public records that can be obtained. So people have been obtaining all these, any records that have been going on that are public relating to a potential sale, which by the way has not been determined by the commissioners. The commissioners have not decided to do this yet. But I will tell you that before that happens, I believe this body will hold a public meeting where the public, as you're doing now, has the right to express their sentiment and to see what it is that's being done. And I think that the public has an interest in this property. It's been public property for I don't know how long. And you know, this commission wanted this property to be self-sustaining, to have a revenue source that was controlled by the Agricultural Society. And in fact, some years ago, we built an event center there. I don't know, it was $4 or $5 million we spent. They operate that, not us, they do, because it's on the fairground. We did that to make it economically viable. There used to be a big viewing stand, do you remember this? And the track, they had actual racing there, and this was for trotting horses. It's now down at the casino. And so that was all torn down, and then we put in this event center, because this body wanted to have a self-sustaining, you know, fairgrounds, and have the Agricultural Society be able to maintain this and have the money to do so. So one of the problems that has come up in recent years is the viability, the financial viability, and that was discussed beginning in October of 2024, because the horse boarding operation was losing a lot of money. And that's one of the reasons, ostensibly, why they wanted to shut it down. So you can understand, none of us here run the fair, but we're interested in it. We want there to be a fair, and we want the 4-H club to have a fair. So I can't speak you know, personally for everybody, it's my understanding that everybody wants to maintain the fair in this county and have the 4-H clubs be able to have that fair.
All right, thank you very much.
You bet.
Thank you for being here today. Is there, yes? Please state your name and address for the record, please. Good
Thank
morning.
you. My name is Catherine Bowles. I'm at 446 Deerfield, right up the street here. I wanted to thank the commissioners for your service and the work you do on behalf of Warren County. I'm here because the Warren County Fair has been a public institution for 175 years, and many residents are struggling to understand why it is now being presented, is now being presented as the only option. For nearly 2 decades, the fair has operated under county oversight. It survived wars, economic depressions, population shifts, and massive changes in agriculture. It served generations of families as a core county institution, and yet today we are being told it's no longer financially sustainable. We have also been told that the situation did not happen overnight. That acknowledgement matters, because if the financial challenges have been building over time, then this did not appear suddenly. This means the county was aware for years that the fairgrounds were becoming more difficult to maintain and operate. Commissioner Young, not here, was elected in 2004. Grossman, you were elected in 2014. Commissioner Jones, 2016. Sorry. Residents are left wondering why, if those warning signs were known, the county allowed the situation to continue deteriorating to the point where a sale is now portrayed as unavoidable. The fairgrounds are under county control. Decisions about maintenance, investment, staffing, long-term planning were made or not made at the county level. Many residents view the current situation as not an unavoidable crisis, but as a result of a long-term deferred maintenance and missed opportunities for reinvestment and reform. The perception deserves to be addressed, honestly. It's worth noting that other Ohio county fairs, like Claremont County Fair, have continued operating for decades. Their success comes from strong management, active community partnerships, and diverse revenue streams that help cover the costs year-round. By contrast, the Warren County Fair has struggled financially despite its long history. Many residents wonder why deferred maintenance and limited investment and reliance on county management have been allowed to bring the fair to this point, and why selling it is now presented as the only option, rather than exploring solutions similar to those used successfully by other counties. Now, after 175 years, selling the fairgrounds is being proposed. Not reinvestment, not restructuring, not new management model, but a permanent transfer of ownership. Once that happens, this cannot be undone. Future commissioners and future residents will have no ability to reverse it, regardless of how circumstances and priorities change. The central justification offered is the city of Lebanon can do what the county cannot. That raises an important issue. If the city has access to funding tools, grants, redevelopment mechanisms that the county does not, then residents deserve to understand why those tools could not be pursued through partnerships or agreements without giving up ownership of a county asset that exists to serve the entire county. The proposal would also make Warren County an exception. To the best of public knowledge, no other city in Ohio owns a county fairgrounds. County fairs are traditionally county responsibilities because they serve county-wide agricultural education, youth development, and rural communities, not just a single municipality. Becoming an exception carries risk, especially over the long term. City leadership changes, economic priorities change, development pressures change. What is promised today in good faith may be revisited tomorrow under different circumstances. That uncertainty weighs heavily on families involved in 4-H and Junior Fair, which are not just events, but educational programs that shape responsibility, leadership, and work ethic in our youth. Verbal assurances are not enough. Residents want to know what legally binding, enforceable protections exist to ensure that the Junior Fair, livestock facilities, and youth agriculture programming remain a priority for decades to come, and what recourse exists if future leaders decide otherwise. Many of us are not opposed to change. We understand financial realities, but we are deeply concerned that a 175-year public institution is being sold because problems developed under your watch, without a full public accounting of how we arrived here or why less permanent solutions were not pursued first. Before this decision is finalized, the community is asking for transparency, accountability, and clarity. Not just about dollars and budgets, but about values, stewardship, and the responsibility that comes with caring for something that generations before us worked so hard to preserve. Thank you so much for your time.
Well, before you leave the podium, remind me of your name again?
Catherine Bowles.
And are you part of the 4-H program, or do you live on a farm too?
I don't live on a farm. I live right up the street here. Yes, my daughter is in 4-H. She has been a 4-H member for 4 years.
Well, great. Well, I like your passion.
Thank you.
However, I'm not sure where you're getting your information, because it's predicated on things that I'm not aware that it is some problem with money that is the issue. And I have been on the board since 2015. I was elected in 2014, and then again in 2018, and again in 2022. Dave Young has been on the board, as you mentioned, starting in 2004 is when he was elected. He joined in 2005. There have been issues, as I understand it, with the fair and certain problems the entire time that I've been on. There's been some questions, and since Dave Young, it's not something that just arose. But the problems with finances and things like that that are real are not the reason for why the Lebanon wants to buy this or what's going on with that. But there will be a hearing where we discuss all of that. But I can tell you right now, that is not a concern of mine at all, is whether or not the fair is making or not making money. I do want them to be self-sustaining. I believe if you looked at the fairs across the state of Ohio, they're not. None of them are in the black. They all cost money. So they don't generate enough funds at the fair or whatever else they're doing with the property in order to make them self-sustaining. I don't mind that. I don't mind this, spending on that money, but we also don't control that property. The state law has been set up, and maybe Bruce, you can tell me if I'm wrong here. The state law is set up so the fairgrounds and where we have the fair is controlled by the Agricultural Society, not by the county commission. And we lease the property to the Agricultural Society to conduct a fair, but we don't manage the property. And we never have had that management obligation nor responsibility. But we do want to get financial data. We do spend money. It is our ground. So yeah, we care about that. We always want to be good stewards with public money. But I don't believe the cost of the fair is an issue with regard to whether it's in the red or the black as to whether or not there's a transaction. So, I mean, it seemed like that was your comment last week, was that it was all about $60,000 or something like that. I can't remember what figure you used. But that isn't what's going on. It isn't about $60,000 about not making money. We do want a fair. We do want to help and support 4-H, which I think that our president, Commissioner Joan, commented about already.
Yeah, and I appreciate you being here today, and I think a lot of the questions you raise, I think, our intention is if and when there's something to ratify or support, that it's incumbent upon us to have a full hearing that details the, accounting of all of the county resources that have been spent or misspent around this, and to have some transparency so that you have your questions answered and understand the rationale behind it. And as I've said previously, unify behind the common purpose of having a fair in the county. And so I appreciate you being here, and I understand your concerns, and they're certainly in the forefront of our mind as we're considering what the next 25, 30 years looks like. We can't dictate what happens in the next 175 years, but I think, we can look at the next 25 to 30 years in the future and secure that, and it's up to those beyond us to continue to maintain this as a priority if the community wishes to continue to do that. So I thank you for being here today.
Thank you.
And Bruce, was there anything that I've said that should be couched differently?
No, you're spot on that the state law vests in the management and control of the fairgrounds in this organization called the Agricultural Society, which I think Commissioner Jones addressed, if not directly, indirectly, is different than the junior fair. And the commitment of this board to the junior fair is a lot different than its relationship with the Agricultural Society. The only thing you said was you mentioned a lease. There is no requirement that there be a written lease between a Board of County Commissioners and the Agricultural Society. In 2009, both organizations decided to enter into a lease. We had a lease, and then that was renegotiated in 2016, and it addressed many financial responsibilities that the Ohio Revised Code doesn't address because it's such an archaic law that's still on the books. I think at this, it's actually a public meeting, not a public hearing, that would occur for this to move forward. There's going to be a lot of information that comes out that will help answer many of the questions that are being posed today. And some of the citizens here today are going to find out, if they don't already know, some very interesting information about how this board has really bent over backwards to provide financial assistance to the Agricultural Society. And the Agricultural Society has not been a good stewards of public funds. That's going to come out in such a meeting. And I think if you're not aware of it, some of it may be shocking to the public.
I don't see anyone else here, so I don't think anyone else wishes to address the board today. Yeah, I'm sorry. I did see you, but
Leslie Miller, 1586 East Lower Springboro Road, Waynesville. I'm Warren's mom. I did not intend to address the board today. I do have some follow-up questions based on what you've shared. It seems to be the consensus that this is not about money. Is that correct?
no, I don't think that's the consensus. I think that Commissioner Grossman was speaking for himself. I'm
Okay.
very concerned about the mismanagement of money by the entity that actually runs the fair.
Okay.
But to clarify, it is not because.
There's a
we have-
shortage.
There's a shortage. I'm saying it's not a
Balance.
matter of, because the commentary by Ms. Bowles last week, and again maybe today, was that this is a dollars and cents because that we weren't making $60,000 or there was some underage. And she was comparing that to our investment that we're making to maintain the tennis tournament here. And that's a legitimate analysis. That, I mean, I see that point of view, but what I'm responding to is, from my standpoint, it isn't because there's a shortfall of if you take a look at the cost of running the fair and the cost of maintaining it as compared to the revenue stream, which, as I mentioned, we put in a very significant building on that site, this event center, to raise money and to have a way of having revenue besides just from the fair.
Yes, incorrect. That building is valued at more than you're willing to sell the entire property for.
I'm familiar with all these issues,
Yeah, not true,
but yeah,
not true.
Well, the public record that you mentioned that's available to all of us has that information. Scott Brunka from the city was representing the city at the Agricultural Society meeting. I'm here before you as a parent from 4-H. We'd love to have you come and sit in on an Agricultural Society meeting and just listen. You don't have to say anything, you don't have to take comment, just listen. And so when I came up and I asked about the comment about, I heard you, Commissioner Grossman, say it's not about money.
it's not, the shortfall in money, that is when you take a look at, if you're doing a profit and loss analysis,
Sure.
if you're taking a look at the fact that it doesn't cash flow, in my view, is not the issue.
And what I did hear is that there's significant issue with the management by the Agricultural Society. Is that correct?
You just heard our lawyer, Mr. McGarry, say that.
Yes, okay. And so my follow-up question is there due process that you have? Is there recourse for malfeasance, nonfeasance? Where is the line when you have these entities who are misappropriating funds that directly impact the youth of this county?
State of Ohio will take care of that, not this board.
Okay.
There's audits, they come in and they audit, things like that. I think there has been an audit.
And the results of that audit are unavailable, not yet completed.
That may be the
Yeah.
case.
That partly could be due that there's inauditable financial records that were kept, but the proper authorities are, is the state and the state auditor.
Yeah, and genuinely, we're here on a fact-finding mission.
Yeah.
We're trying to do what's right by the youth of the county. So I appreciate your time today.
Thank
Thank
you.
you.
Thank you for being here
You
today.
should be congratulating your son.
Thank
I like him very much. I'm sure you do too.
I think I'll keep it.
It's
Okay.
good.
Is
And-
there
and
any,
I was gonna ask him a question. Are you, what grade are you in? Were you a sophomore, you said?
Yes, sir.
Oh, okay. So are you planning to go to college?
No, I'm actually planning on, going to Wright Pat, or the Wright Pat School of Aviation and becoming either a pilot or, aviation mechanic.
Super. Well, great. Well, it's really been a pleasure meeting you today.
You too.
thank you for being here.
And thank you, Ms. Bowles, as well.
Anything else to come before the board today? Seeing none, I'll entertain a motion to adjourn.
So moved.
And yes. Thanks, everyone. I'm half hour late.